How to write a will that is clear, thorough, and legally binding. A basic will may be all you need, and here is how to write a comprehensive and legally sound one. Depending upon your situation, you may not need to spend several $100s and hire an attorney to create a basic will for you. This video can be beneficial to all viewers, including those who are single or own almost nothing, as legal experts say those people also need a will and or some kind of other legal protection in case they unexpectedly die or become incapacitated. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. I'm doing marvelous, if you were to ask me. And if you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today I want to talk to you about how to write a will that is clear, thorough, and legally binding. Let's first talk about how to write a basic will yourself. If you ever decide to write your own will, you probably want some help creating your documents. You want to know what to include, and you want to know how to make it legal. You have will templates on the internet. First, choose a tool to help you write your will. You might use a book that gives you a variety of will clauses that you put together, or you might use a program that puts it together for you. It doesn't matter, it depends on your preferences. In any case, you will want to make a document that is typed, because although handwritten wills are permitted in some states, we live in the 21st century, folks. So creating a formal typed document is less likely to cause trouble after your death. You want to find a will making tool that you can trust. There are several types on the internet. You have flat forms. Those allow you just sit around, fill in the blank documents that you can edit with your word processor. Those are the flat forms. Then you have the statutory forms. Those are forms written into the laws of just a few states. You have will books. Those are books out there, and you can even have them electronically that provide thorough instructions for filling out flat forms, and they may also offer additional information about estate planning. You have will software. Some are free, some are paid. With estate planning software, you answer quote-unquote interview questions. They have a checklist, and so you have some kind of interrogation, some kind of survey. So you have interview questions. Then the program builds the will for you based on the answers you provided for those interview questions. You also have online will programs. So these are kind of similar to will software, but instead of loading the program on the computer, you make your will on the internet. No matter what type of will template you prefer, make sure to choose one that comes with clear, plain English instructions so that you can feel confident that you're making a will that does exactly what you want it to do. Because legalese can be a little complicated. We all know that unless you spend several years at a law school, most of us do not understand legalese, like advanced legalese. So choose a will template or a will making tool that speaks English, that speaks plain English. What to include in your will? Let's talk about that. No state requires specific language to make a will. State authorities are pretty flexible. The best wills are those that clearly reflect the wishes of the will maker. So what you include in your will depends on what you want your will to do for you. Most people used a will to distribute their property after they die. So a will can also name your executor, name guardians for young children and their property, state how to pay debts and taxes, provide for pets, and serve as a backup for a living trust. We have covered the term living trust in another show. You might want to double check that. It's a great show, and it will tell you a lot about what a living trust is and why a living trust is different from a will. Let's talk now about some things you should not try to do in your will. Do not put conditions on your gifts. For instance, I give my house to Mary if she finishes college. This does not fly when it comes to a legally binding will. Do not leave instructions for final arrangements. There are other documents, other areas of the law where you can specify such arrangements or such instructions. Do not leave property for your pets. Do not leave instructions regarding health care. You have durable power of attorney for health care and other documents for that. In your will, don't make arrangement for money or property that will be left another way, such as property in a trust or property for which you have named a pay on death beneficiary. Those are big no-nos. How do you make your will legal? Let's talk about that. So after you use the will template to write your will, you need to do a few things to make it legal. And making it legal is critical. And there are a few requirements here. Sign your will. First thing is you want to sign your will. Basically, you want to, again, by signing, I'm not talking about using those software, those electronic signature. I'm talking about taking a piece of paper, taking a pen and signing manually. You also want to have 2 witnesses sign your will. In most states, have a notary sign a self-proven affidavit. This is optional. Now, your witnesses do not need to know what's in your will. They don't have to. Don't feel under pressure. They don't have to. You want to simply gather them around, say, this is my will, and have them sign. You got to say, this is my will. They need to know what they're signing. Wills do not need to be signed by a notary public to be legal and binding. However, in most states, you can also attach a self-proven affidavit, and those must be signed by a notary public. Self-proven affidavits do not affect the legality of your will, but they do make your will easier to probate after your death. Think of it as another layer of legal strength or legal corroboration. Let's now talk about notarizing and witnessing legal documents during the COVID crisis. This is important because even though the COVID crisis will be something temporary, we might have a similar situation in the future, whether when it comes to a health pandemic or something of that nature. So it is kind of critical to understand that. During the current pandemic, commercial restrictions and social distancing have made it harder to finalize a diverse range of legal and financial documents. But you can still notarize documents while under the COVID restrictions. Now, to have a document notarized, you got to physically appear before the notary public. You do not always have to sign the document in front of the notary though, but at the very least, the notary must see you as you prove and acknowledge that you are the signer. In these times, states are reconsidering what it means to physically appear, frequently allowing notaries to do their work on the internet. The great thing is, even before the pandemic, some states passed laws and issued regulations allowing something called RON, remote online notarization. And this RON scheme, allows notaries to acknowledge documents without in-person meetings. We have states such as Michigan, Minnesota, Florida, Kentucky, Montana, Nevada, Ohio, Wisconsin, Washington State, Virginia, Utah, Texas, Tennessee. All those states are early adopters. Now, in response to the COVID crisis, many other states have fast-tracked laws to permit this process, and the federal government is considering a national law, which will be fantastic, because usually the probate process and the estate planning is usually left to states legislatures. Because we have extraordinary circumstances, if the federal government gets involved, this will be wonderful in that aspect. So we have a national law, and we have some kind of a uniform, the same thing we have for business, where we have the UCC, the Uniform Commercial Code. It'll be nice to have some kind of a uniformity when it comes to the legal aspect of estate planning. A handful of states So far, I'm talking about New York, New Hampshire, Iowa, and Connecticut have temporarily authorized online notarization because of the pandemic. So there is a website you can reach, you can check. It's the website of the Mortgage Bankers Association that gives you a regularly updated map showing states that are allowing run. You can get details on where your state stands and how to use online notarization by contacting a local mortgage professional or a estate planning lawyer. You can even contact your Secretary of State's office, which is in charge of regulating notaries in most states. If you must have a legal or a financial document to notarize and online notarization is not available to you, there is something else you can do. Let's just get into that here. The thing is, you got to get creative. You got to use your innovation, your imagination. You can witness when it comes to witnessing or notarizing legal documents in person. You can be a little creative. For instance, if your document requires witnesses, most states requires you to sign the documents while the witnesses are watching. It doesn't mean the witnesses have to be closer to you in close range. They can be afar and still witness you, right? The word here is witness. They have to see you do it. Then the witnesses might sign the documents themselves. Some states allow exceptions to this rule. So you have flexibility when it comes to signing the documents now. So you can sign the documents now and have witnesses sign later. In all cases, be sure you are clear on your state's law for the documents you're signing before you go that route. If you and your witnesses have to sign a legal document together, or if for some reason online authorization is not available to you, you may be able to find a creative way to solve this problem. For example, you can make in a shopping mall, in a parking lot, at a food court, instead of in closed offices. You can even meet on a football stadium, right? The notary then will watch you from afar, let's say from a reasonable distance. They will watch you as you and the two other witnesses sign their documents. After this, the notary will come out, will find a way to exchange the documents. Maybe you can just put the documents on the floor, put a stone on it in case it's windy, right? So, and they will pick up the documents later. You might say this is complicated. It's not. It's all about being creative. It's all about thinking outside the box. This is the kind of buzzword you hear consultants use sometimes. It might be complicated. You might think it's complicated, but you get the point. The point here is to be creative and find a way to meet the state's requirements without being in close range, without being face to face with a person. You want to think through your circumstances and surroundings to see if you can come up with an inventive solution that meets the requirements of the law and also keeps everyone safe. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are still talking about how to write a will that is clear, thorough, and legally binding. And let's talk now about writing a basic will, even if you are single or own almost nothing. This is something we hear a lot of people say. People are saying, I am single, I have nothing to my name, I don't need a will. No, you do. Even if you're single, even if you are in your 20s, you're in your 30s, even if you believe that you have meager savings, you live in a rental apartment, you have no children, you still need to write a will. You have to. Most state laws gives everything to the dearly departed parents or other close relatives. In other words, if there is no will to specify what you want, the probate process in most states will assign your whatever you have. Is it a piece of jewelry? Is it a ring that your grandmother gave you? Is it something emotional? Is it your diary when you were in 5th grade? Here, we're not talking about just physical asset like monetarily important asset. We're not talking about property. We're talking about things that are dear to you, that are emotionally attached to you. If you don't have a will, those items will go to your close relatives. But what if you don't want? What if you would not have wanted that? So you want to pay attention to that. So writing a will might be a good idea to specify whom you want things to be given to. Also, think about the items you hoped your parents will never see. Things that are so secretive, things that are secret, they're important to you that you don't want anybody to know about. So this is why you need to have a will. So also in your will, you can designate who will be your executor, the person with authority to make sure that all your possessions end up in the right hands. If you do not write a will now, be sure to do so very quickly. And once you do, be sure to revisit the issue as your circumstances evolve. So your estate planning needs will change if you have children, if you accumulate more property, if you develop health problems, or you just reach a later stage in life. You're getting old. So you want to have that. Doesn't matter your situation, doesn't matter your assets, it doesn't matter your where you are in your life, you need a will. Let's now talk about when a basic will is not enough. Again, folks, throughout this conversation, I've been talking about a basic will, right? Because if you have a convoluted will, it's just better to go to an attorney. Even if you have a basic will, but you want to have peace of mind, it's always good to go to an attorney. If you are under age 50 and do not expect to leave assets valuable enough to be subject to estate taxes, you can probably get by with only a basic will. But as you grow older and acquire more property, you may want to engage in more sophisticated planning. Let's talk about those planning here. Take a common situation where a husband and wife want to leave their property to each other, or if they die together, to their children in equal shares. They also want to name a personal guardian for their children. They can safely make simple wills themselves without hiring a costly expert. Let me give you a few other examples of real life situations where a basic will is all that's needed. Let's say that you have a couple in their 30s, they have some savings, they own a home, they have 2 cars. Their net worth totals $500,000. They have 1 child, John, age 13. So each prepares a will, so that each partner prepares a will, leaving all his or her property to the other. If they die at the same time, John, the 13-year-old son, will receive all their property. The couple may agree that the husband's brother will care for Mark and manage the property, will care for John rather, and manage the property until John turns 18. That's the first real life situation where you have a couple with 1 child. Let's have a second situation here. Let's say you have Emmanuel is a widower with 3 grown children, and he owns property with a net worth of $1 million. He can create a will leaving all his property equally to the children, to the adult children. He can specify that if any child dies before him, that child's share is to be divided equally between the surviving children. A third scenario that could be a real life example is, let's say you have Mary. Mary is a single mother with 2 teenage kids. She's not on great terms with her ex-husband. However, the man is a decent father and pays child support more or less on time. Mary's will leaves all her property equally to her children. Because she does not want her ex-husband managing money left to her children if she dies, she uses her will to appoint her sister to manage each child's property until the child turns 18. So I just gave you 3 scenarios, 3 real life scenarios you can go through to understand the importance of a basic will. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are doing fantastic. I'm still here having a conversation around how to write a will that is clear, thorough, and legally binding. I hope you're learning a lot through this show. I really appreciate it. If you do, please leave us a comment, share this content, and like it. Also, you can subscribe to our channel and turn on the notification bell so when we release a new show, as we do every single day, you will be the first one to be informed. Will a basic will avoid probate? The answer is no. No. If you leave anything more than a small amount of property through a will, probate court proceedings will probably be necessary after your death. Although the processes vary, the probate processes vary from state to state, they can take 6 months or a year and eat up 3 to 5% of your estate and lawyers and court fees. And your beneficiaries will probably get little or nothing until probate is complete. Having said that, if you need only a basic will, you will have little reason to concern yourself now with probate anyway, right? If you're relatively young and healthy and you don't have piles of money sitting around, your real concern is to make legal arrangement for the statistically unlikely event that you will die suddenly and unexpectedly. You've almost certainly got plenty of time to plan for probate avoidance later. Is a basic will for you? Let's just talk about that. A basic will is probably enough for you if you are under age 50, you are in pretty good health, you do not expect to owe estate tax at your death. On the other hand, if any of the following applies to your situation, then you probably need something more than a basic will, in which case you have to reach out to an attorney. Let's say you expect to owe estate tax after you die or when your spouse dies. You want to control what happens to property after your death. For example, you want to leave some property in trust for your child and have it go to your grandchildren when your child dies. Or you have a kid with a disability or other special need that you wish to address in your estate plan. You can also you need more than a basic will if you have children from a prior marriage and you're kind of scared that there might be conflict between them and your current spouse. Or if you think someone might contest your will, claiming that you were not mentally competent when writing it, or that the will was procured by fraud or duress, then you can have more than you will need more than a basic will. The word duress here is a legal term that means pressure. So if anything that is done, any legal act that has been accomplished under duress is generally nullified by the court. Duress spells D-U-R-E-S-S. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another section of the Awesome Sweetie Kiwi Show. I'm still happy to have you around here. Now let's talk about having a lawyer write your will. Again, we're not providing any kind of legal advice here. It's always better to reach out to an attorney because the attorney has the expertise, the experience, and can customize a will that fits with your personal situation. So if you decide that your situation is too complicated or convoluted to write your own will, or if you would just have a professional do it, then you will need a lawyer's help. Remember though, that hiring a lawyer does not mean you need to hand over the entire process or spend an outrageous amount of money. Rather, you can educate yourself about the law. It's useful because it will save you money. It will help you familiarize yourself with what's going to happen to you, to your asset after you're gone, or even before you're gone. You will need less time with the attorney and increase the likelihood that the attorney will draft a document that reflects your wishes. So this is it, folks. This is the end of today's conversation. I was talking to you about how to write a will that is clear, thorough, and legally binding. Here is a recap of today's conversation. I spoke to you about how to write a basic will yourself through a will template. I spoke to you about what to include in your will, making your will legal, notarizing and witnessing legal documents during a pandemic or other crisis when you have to do it online or innovative when it comes to finding a way to meeting the state's laws requirements of having witnesses, of having a document notarized without being in close contact, in close range with a person. I also spoke about writing a basic will even if you're single or own almost nothing. I spoke about when a basic will is enough. Will a basic will avoid probate? The answer is clear no. Is a basic will for you? Really depends on your situation. And the last thing I spoke about is having a lawyer write your will. I will see you next time. But until then, remember, stay marvelous.